Welcome to the Deep Dive, the show where we take a stack of dense information and extract the most important nuggets of knowledge, giving you a shortcut to being truly well-informed.
And today, we're really diving deep, aren't we?
We absolutely are. We're plunging into the profound and pretty intricate constitutional architecture of India, the world's largest democracy.
Mm-hmm.
And we're starting with some insights that might just surprise you. I mean, did you know there's a type of law in India that can technically pass without the upper house's full approval?
Or, and this is a big one, that judges in India essentially choose their own successors. It sounds almost unbelievable when you put it like that.
Right. And these aren't just, dry legal facts. They're the fascinating kind of behind-the-scenes mechanics that shape how a nation of over 1 billion people governs itself.
What's truly illuminating here, I think, is how these seemingly technical details really unveil the core power dynamics. You see the delicate balance, the unique evolution of a modern, complex governance system.
Exactly. We're talking about Articles 107 all the way through 127 of the Indian Constitution.
Yeah, quite a chunk.
It covers everything from Parliament's lawmaking process, the president's pivotal roles, to the dynamic and sometimes, let's face it, fiercely contentious evolution of the Supreme Court.
That's a good word for it, contentious.
We've compiled a stack of detailed legal analyses and scholarly excerpts, and the goal isn't just to present facts. It's more to reveal the practical implications, the historical shifts, and the ongoing debates that make India's constitutional journey so compelling.
So our mission today, really, is to cut through any legal jargon
Please.
and deliver the most impactful insights, give you a clear, concise, and hopefully incredibly informative understanding of India's intricate governance.
Yeah, you should gain a real appreciation for the extraordinary thought that went into building these institutions, and maybe more interestingly, where the intriguing tensions still lie.
And if we connect this to the bigger picture, right, these articles aren't just about abstract legal principles. They are the scaffolding, really, upon which power is distributed, constrained, and ultimately held accountable within a vibrant democratic republic.
Absolutely. Whether you're prepping for a crucial meeting, exploring a new field, or just genuinely curious about how a nation of this scale navigates its future, this deep dive is tailored for you.
Get ready for some aha moments.
Definitely some aha moments that connect the constitutional text directly to real-world power dynamics. So let's unpack this and jump right into the legislative engine room.
The legislative engine room, how laws are made.
So let's begin with the fundamental process of lawmaking. Ordinary bills. These are the non-financial pieces of legislation that, form the bulk of parliamentary business.
Right. And Article 107, it sets the stage for how these bills are introduced and passed. It lays down the foundational rules for India's bicameral parliament.
Bicameral, meaning two houses.
Exactly. Article 107 establishes that core principle. Ordinary bills can originate in either the Lok Sabha,
That's the House of the People, the directly elected one.
correct, or the Rajya Sabha, the Council of States.
Okay.
This immediately highlights that bicameral nature. Both houses play a significant, often interdependent role.
So they both have to agree.
Pretty much.
Hmm.
For an ordinary bill to be considered passed, both houses must agree to it, either without amendment or with amendments that both houses concur on.
Yeah.
This bicameral concurrence is central.
Okay. And here's where it gets tricky, I think. The journey of a bill. It can get quite complex, right? Even precarious. Especially this distinction between the end of a session and the end of a government.
Ah, yes. Many might assume a bill just dies if Parliament goes on recess, but no, that's not always the case. It's a critical legal and political distinction.
So what's the difference?
Well, if a session of Parliament simply ends, that's called prorogation, a pending bill does not lapse.
It doesn't.
Okay. No, it carries over. It can be taken up in the next session. That ensures continuity in legislative work. However, the dissolution of the Lok Sabha.
Right, when elections happen.
Exactly. That's a seismic event. It's a fundamental resetting of the legislative clock.
So what happens to bills then?
A bill pending in the Lok Sabha, whether it started there or came from the Rajya Sabha, it lapses. Gone.
Okay.
Similarly, a bill passed by the Lok Sabha, but still pending in the Rajya Sabha, also lapses.
So dissolution is pretty final for most bills. Is there any exception?
There is one key exception, a bill that originated in the Rajya Sabha and is still pending there, and importantly has not yet been passed by the Lok Sabha.
Okay.
That one does not lapse upon Lok Sabha's dissolution. It survives.
Yeah.
This preserves some legislative stability for the upper house, the continuing body.
So, what's the real-world impact of this? Why this big difference between prorogation and dissolution?
Well, it vividly illustrates the Lok Sabha's direct accountability to the electorate, doesn't it?
Because it's directly elected.
Precisely. The Lok Sabha reflects the current popular mandate. When it dissolves, a new Lok Sabha is elected, presumably with a fresh mandate. Bills from the previous mandate generally die, allowing the new government and parliament to start afresh, reflecting the updated will of the people.
And the Rajya Sabha.
The Rajya Sabha, conversely, is a continuing body. It's never fully dissolved, so it offers a degree of legislative stability. Bills originating there, which haven't reached the Lok Sabha yet, are protected. It highlights its more enduring nature.
I can easily imagine the political drama here. Picture a key education reform bill, championed by the ruling party, passes the Lok Sabha, big celebrations, but then gets stuck in the Rajya Sabha.
Happens all the time.
And if a general election is called, Lok Sabha dissolves before the upper house passes it. Poof! That bill essentially dies with the government that pushed it.
Exactly. All that political capital, all that effort, basically reset to zero. It underscores the political stakes involved in getting legislation through both chambers before a potential electoral cycle interrupts it.
Okay, so that's the life cycle. But what if, despite all these rules, the two houses just can't agree on an ordinary bill, deadlock? What happens then?
That's where Article 108 comes in. It provides a constitutional escape valve, a way out.
The joint sitting.
The joint sitting, yes. It sounds the ultimate tiebreaker in a legislative standoff.
So what triggers it? What are the specific conditions?
The president may summon a joint sitting under 3 specific conditions. First, if one house rejects a bill passed by the other.
Okay, outright rejection.
Second, if the houses have finally disagreed on amendments, back and forth, still no agreement.
Right.
Or third, if more than 6 months have passed since a bill was transmitted to the other house without it being passed.
6 months is quite a long time.
It is. So this mechanism is crucial to prevent legislative paralysis. Ensures important legislation doesn't just languish indefinitely due to inter-house disagreement. Once a joint sitting is notified, neither house can proceed with the bill independently. Everything goes to this combined form.
And how does it actually work? Who's in charge? How do they decide?
The joint sitting is presided over by the Speaker of the Lok Sabha.
A Lok Sabha speaker, okay.
And decisions are made by a simple majority of the total members of both houses present and voting.
Simple majority. But wait, the Lok Sabha has way more members than the Rajya Sabha, doesn't it?
It does. Significantly larger, roughly twice the size. And that numerical advantage is critical.
So the Lok Sabha's view almost always wins out.
In almost all cases, yes.
Mm-hmm.
It ensures the will of the directly elected lower house prevails, effectively breaking the deadlock and reflecting that popular mandate.
That seems like a powerful way to ensure things don't get stuck. But are there any types of bills that don't get this joint sitting treatment? Maybe things too important or too different?
Yes, absolutely. There are crucial exclusions. This mechanism is not available for money bills,
Okay, finance bills.
which have their own special Lok Sabha dominant procedures we'll get to, and also not for constitutional amendment bills.
Changing the Constitution itself.
Right. Those require separate special majorities in each house, with no provision for joint sittings to resolve disagreements. That highlights the unique importance and procedural rigor applied to financial matters and fundamental constitutional changes.
Has this joint sitting mechanism actually been used much?
It's not common, but yes. A notable historical instance was for the Dowry Prohibition Bill back in 1960. It demonstrates its utility in overcoming stalemates, especially on important social legislation.
Okay, so we've covered ordinary bills, their paths, the whole prorogation versus dissolution thing, and the deadlock resolution. But now, what about the really sensitive area of financial legislation?
Yes, money bills.
That's where the power dynamics shift quite dramatically, right?
Indeed. Money bills, governed by Articles 109 and 110, represent a fundamental principle of parliamentary democracy, that the power of the purse rests primarily with the directly elected representatives.
The ones directly accountable to the taxpayers. Makes sense.
Exactly. And Article 109 in particular really spells out the Lok Sabha's dominant role here, almost to the exclusion of the Rajya Sabha.
How dominant are we talking?
Unequivocally dominant. Article 109 states that a money bill can only be introduced in the Lok Sabha.
Only Lok Sabha. Rajya Sabha can't even start one.
Nope, no power to initiate. Once passed by the Lok Sabha, it's transmitted to the Rajya Sabha, but only for its recommendation.
Just recommendations, not amendments.
Just recommendations. And they have strict, very short time limit, 14 days to return the bill with suggestions.
14 days, that's nothing.
It's tight. And critically, the Rajya Sabha cannot reject or amend the bill directly. Its role is purely advisory.
So Rajya Sabha can offer suggestions, but the Lok Sabha holds all the cards. What if Lok Sabha doesn't like the suggestions? Or what if Rajya Sabha just, sits on it for those 14 days?
Good questions. The Lok Sabha has the sole discretion to accept or reject any or all of the Rajya Sabha's recommendations.
Any or all, wow.
If the Lok Sabha accepts any, the bill is deemed passed by both houses with those accepted amendments. If it rejects all of them, the bill is deemed passed in the form it was originally passed by the Lok Sabha.
And if the 14 days just lapse?
Then the bill is automatically deemed to have been passed by both houses in the form it was passed by the Lok Sabha.
So no way for the Rajya Sabha to block it.
Effectively, no. This ensures the speedy passage of crucial financial legislation, preventing any obstruction by the upper house on matters of national finance.
That's a massive power asymmetry, especially for the Rajya Sabha, which often represents regional interests. Has this ever led to, accusations of the Lok Sabha just steamrolling the upper house?
Oh, absolutely. Politically, yes, but constitutionally, this procedure reflects that fundamental principle. No taxation without representation, vesting primary control over public finances with the directly elected Lok Sabha.
Because they're directly accountable for how taxpayer money is raised and spent.
Precisely. The annual union budget comprising the Appropriation Bill and the Finance Bill, these are the classic examples of money bills that follow this accelerated Lok Sabha-centric procedure. The political criticism usually centers on whether the definition of a money bill has been stretched sometimes, maybe to avoid Rajya Sabha scrutiny on other matters.
Ah, okay. That leads right to the next question. How do we even know if a bill qualifies as a money bill? And not just any bill with some financial bit in it. That sounds like it could be a huge point of contention.
It absolutely can be. And that's precisely where Article 110 comes in. It provides an exhaustive and quite precise definition.
Exhaustive, meaning it lists everything.
Yes. A bill is deemed a money bill only if it contains provisions dealing specifically with matters related to the government's core financial operations.
Like what, for example?
Things like the imposition, abolition, or regulation of any tax by the union, the regulation of government borrowing or guarantees, custody of the Consolidated Fund or Contingency Fund of India, and transactions related to them, the appropriation of monies from the Consolidated Fund, declaring expenditure as charged on the Consolidated Fund, or the receipt, custody, or issue of public money, or audit of accounts, and anything purely incidental to these.
That sounds very specific. You mentioned the word only there. How important is that?
Only is a small word, but it carries immense constitutional weight, exceptionally critical.
Why? What if a bill has some financial stuff, but also other non-financial provisions? Does that still count?
No. That's the crucial caveat and often a point of political debate. A bill is not a money bill merely because it imposes fines or fees for licenses or services or deals with local taxes for local authorities.
Okay.
If a bill contains even one provision outside these strictly specified financial matters listed in Article 110, it generally cannot be classified as a money bill.
So it prevents governments from just sneaking non-financial things through by calling it a money bill.
Exactly. It prevents bypassing the Rajya Sabha on broader legislation by cleverly tagging on minor financial clauses. It acts as a constitutional gatekeeper, ensuring only true financial matters get this fast-track Lok Sabha dominant treatment.
And who gets the final say if there's a dispute? If someone says, hey, this isn't really a money bill.
If any question arises, the Speaker of the Lok Sabha's decision shall be final. The Speaker also has to certify a bill as a money bill before it's sent to the Rajya Sabha or the President.
Shall be final. That sounds pretty absolute. Is it?
Well, it sounds absolute, but there's a twist, a judicial check.
Ah, the courts get involved.
Yes. In the landmark K.S. Puttaswamy case, the Adhar judgment, back in 2019, the Supreme Court indicated that while the Speaker's decision is final, it is not entirely immune from judicial review.
Really? On what grounds?
If the decision is shown to be patently erroneous, perverse, or made in bad faith.
So basically, if the Speaker clearly got it wrong or acted improperly.
Exactly. This nuanced interpretation places a crucial check on what might seem like an absolute power, ensuring it cannot be used, say, to deliberately circumvent the Rajya Sabha's constitutional role on non-money matters.
That's a classic example, isn't it? The judiciary stepping in to interpret and define the limits of parliamentary power, even when the text seems crystal clear.
It really is. It shows the Constitution as a living document.
Okay, so we've got ordinary bills, money bills, but you mentioned there's a third category, something in between.
Yes, there's a hybrid category. Financial bills.
Yep.
Article 117 deals with these. They aren't strictly money bills, but they still carry significant financial implications for the government.
So like a mix of money matters and general law.
Essentially, yes. They contain some elements of money bills alongside general legislative matters. The Constitution divides these into two categories, each with slightly different procedural rules.
Okay, let's break that down. Category I, financial bills, under Article 117(1). What are they?
Category I financial bills contain some of the matters specified in Article 110(1), things like taxation or appropriation. But, crucially, they also include other provisions of general legislation.
So not only financial matters.
Correct. And because of that financial element, there are special procedures, like money bills, that can only be introduced in the Lok Sabha.
Okay, Lok Sabha again.
And they require the president's recommendation for their introduction.
President's recommendation, why?
It signifies the government's approval and initiative for legislation that impacts public funds. The executive basically have to sign off on introducing it.
That sounds like a significant hurdle, puts the executive firmly in control. Is there any exception to needing that recommendation?
There is, actually, and it's a fascinating little detail. No president's recommendation is needed for an amendment to a financial bill that seeks to reduce or abolish a tax.
Really? So Parliament can propose tax cuts without government pre-approval?
On its own initiative, yes, through an amendment. It highlights a subtle avenue for legislative influence on taxation, specifically relief. But once introduced, these Category E financial bills are otherwise treated like ordinary bills.
Meaning the Rajya Sabha can amend or reject them?
Yes, and a joint sitting can be called if there's a deadlock, unlike money bills.
Okay, that makes sense. Now, what about Category 2 financial bills under Article 117(3)? How are they different?
These are interesting. Category 2 bills do not contain matters from Article 110(1), so they aren't about taxation or direct appropriation. But if enacted, they would involve expenditure from the Consolidated Fund of India.
Give me an example.
Think of a bill setting up a new social welfare scheme. It will definitely cost money from the government's main account, but the bill itself isn't imposing the tax to fund it or directly appropriating the money.
Got it. So what's the special procedure for these?
They can be introduced in either House, Lok Sabha, or Rajya Sabha, so more like an ordinary bill in that sense. However, and this is the key, such a bill cannot be passed by either house unless the president has recommended its consideration to that house.
Consideration, not introduction.
Right. This recommendation can be obtained at any stage before the bill's final passage. So the government gets a crucial say before any bill that costs public money actually becomes law, even if it wasn't about taxes initially.
So why all these intricate classifications? Ordinary, money, financial category first, financial category 2. It seems designed to be quite complex.
It is complex, but it serves a vital purpose. This intricate system ensures that any legislation impacting public funds, even indirectly, still requires the executive's initiative or approval via the president's recommendation.
Why is that so important?
It promotes financial prudence and accountability. The government is ultimately responsible for managing the nation's finances, so it needs control over proposals that spend money. But at the same time, these classifications still allow for broad legislative debate and scrutiny by Parliament, unlike the very restricted process for money bills. It's about balancing executive financial control with parliamentary oversight.
That makes sense. It's a complex balance. So Parliament makes laws through these various paths. But of course, the head of state, the president, also plays a crucial, often final role. Let's shift focus now to the president's powers in this legislative process.
The president's role in lawmaking and emergency powers.
Indeed. And Article 111 is where the president formally enters the picture. It outlines the final critical step for a bill to become an act, the president's assent.
The final seal of approval.
Exactly. Without it, a bill passed by both houses remains just that, a bill, devoid of legal force.
So what options does the president actually have when a bill lands on their desk, having cleared both Lok Sabha and Rajya Sabha?
Upon presentation, the president has three main options. First, the straightforward one. They can simply give assent. The bill immediately becomes an act, a binding law.
Okay, simple enough.
Second, they can withhold assent. This is essentially an absolute veto.
Meaning the bill is just dead.
Yes. If assent is withheld, the bill does not become law. Now, this is quite rare and typically exercised only on ministerial advice. Perhaps if the government itself has had second thoughts after it passed Parliament.
Okay. And the third option.
Third, and this is where it gets more nuanced, the president can return the bill for reconsideration. This is known as a suspensive veto.
Suspensive veto. How does that work? Can Parliament push back?
Yes, the president can return a bill, but only if it is not a money bill back to Parliament. They can request reconsideration of the entire bill,
Yeah.
specific provisions, or suggest amendments. Parliament then shall reconsider it.
They have to reconsider it.
The Constitution says shall reconsider. And here's the crucial check on presidential power. If Parliament passes the bill again, with or without accepting the president's suggestions, and presents it a second time,
Then what?
the president shall not withhold assent therefrom.
Ah. So Parliament gets the final word if they insist.
Exactly. Parliament can ultimately override this suspensive veto, reaffirming its legislative will. It ensures the president cannot permanently block a bill that has strong parliamentary backing.
That's a powerful mechanism for a final check. But you mentioned it doesn't apply to money bills. Why the exception there?
No, the power to return a bill for reconsideration does not apply to money bills. For those, the president can only either assent or withhold assent.
Why?
It reinforces the Lok Sabha's financial supremacy. Plus, money bills usually reflect the executive's own financial proposals anyway, having originated with the president's recommendation, and their swift passage is deemed critical for government functioning. Returning them would defeat that purpose.
Makes sense. And then there's this famous, almost mythical thing. The pocket veto. What's that all about? Sounds intriguing.
It is intriguing. It's not explicitly written down, which makes it fascinating. It arises from what the Constitution doesn't say.
What doesn't it say?
Article 111 doesn't specify a time limit within which the president must act on a bill presented for assent.
No deadline. At all.
No deadline. This omission implies a pocket veto. The president can simply keep a bill pending indefinitely without acting on it, neither assenting nor returning it for reconsideration.
So they just put it in their pocket, metaphorically speaking.
Exactly. This effectively kills the bill through inaction, without needing to state a reason or face a parliamentary override.
Has this actually been used?
Yes, famously. President Zail Singh used this pocket veto back in 1986 on the Indian Post Office Amendment Bill. He neither assented nor returned it, and it simply never became law. It's a testament to the power of silence or omission in a constitutional text.
Wow. So summing up Article 111, how important is this presidential role in the grand scheme?
It positions the president as an integral, albeit often formal, part of the legislative process. It provides a final check against, perhaps, hasty or ill-conceived legislation, even though the president largely acts on the advice of the Council of Ministers.
Which is the real executive power center.
Correct. This power ensures a moment of executive review before a bill becomes binding law. It's a key part of the delicate checks and balances. And the existence of the pocket veto highlights a surprising, unwritten power that still exists.
Okay. Beyond the final say on bills, the president also has this unique, almost emergency legislative power for times when Parliament isn't in session and urgent action is needed. The ordinance power. Article 123.
Yes, Article 123 grants the president a powerful yet temporary legislative authority, the power to promulgate ordinances.
Making laws without Parliament.
Essentially, yes, but only when Parliament is not in session and circumstances demand immediate action. It's temporary lawmaking by the executive, designed for genuinely urgent situations where the regular legislative process would simply be too slow.
What are the specific conditions? Can the president decide something is urgent?
Two main conditions must be met. First, both houses of Parliament must not be in session. If even one house is sitting, an ordinance cannot be issued.
Both have to be in recess.
Okay. Second, the president must be satisfied that circumstances exist which render it necessary for him to take immediate action.
Satisfied. That sounds a bit subjective.
It does, but, and this is crucial, this satisfaction is not the president's personal whim. It's based on the aid and advice of the Council of Ministers.
Ah, so it's really the government deciding it's necessary.
Correct. It reflects the parliamentary nature of India's executive. Real power lies with the elected government advising the president.
And how much weight does an ordinance carry? Is it like a full law?
Yes, an ordinance has the same force and effect as an act of parliament.
So it carries the full weight of law.
It does, but critically, only for a limited period. This temporary nature and the requirement for parliamentary control are key safeguards against executive overreach.
How is that control exercised?
Every ordinance must be laid before both houses when they reassemble. And it automatically ceases to operate 6 weeks from the reassembly of Parliament.
6 weeks, that's it.
6 weeks from reassembly. If the houses reassemble on different dates, the 6 weeks are counted from the later date. So Parliament gets a chance to review it and decide its fate relatively quickly.
Can Parliament make it disappear even sooner than 6 weeks?
Absolutely. An ordinance ceases to operate even earlier if both houses pass resolutions disapproving it.
Okay.
The president can also withdraw an ordinance at any time, usually on the advice of the government. And importantly, an ordinance is void if it makes any provision that Parliament itself wouldn't be competent to enact, say, legislating on a state subject or violating fundamental rights. It can't bypass constitutional limits.
Now, you mentioned the president's satisfaction earlier. That specific point has been a source of major debate in court cases, hasn't it? Can the courts look into whether the president, or rather the government, was really satisfied?
This is where the power gets truly tested and where the judiciary plays a huge role. There was an attempt via a constitutional amendment to make the president's satisfaction non-justiciable, meaning beyond the reach of the courts.
To shield it from review.
Exactly. But the 44th Amendment removed that shield. Landmark Supreme Court judgments like R.C. Cooper in 1970 and A.K. Roy in 1982 firmly established that the president's satisfaction is not immune from judicial review.
So the courts can examine the reasons.
Yes, it can be challenged. The courts can look into it on grounds of malefides, bad faith, or dishonest intention.
Okay.
Extraneous considerations, meaning factors were considered that shouldn't have been, or if the promulgation itself constitutes a fraud on the Constitution.
For fraud on the Constitution.
Yeah.
That sounds incredibly serious. What does that mean in the context of ordinances?
It refers specifically to the practice of repeatedly repromulgating ordinances without ever getting them passed as proper acts by Parliament.
Just keeping the temporary law going indefinitely by issuing it again and again.
Precisely. The Supreme Court, in cases like D.C. Wadhwa v. State of Bihar in '87 and Krishna Kumar Singh v. State of Bihar in 2017, strongly condemned this. They called it a fraud on the Constitution and a grave abuse of power.
Why is it seen as so bad?
Because it's seen as a deliberate bypass of democratic legislative scrutiny. It effectively creates a parallel, undemocratic lawmaking process that completely undermines Parliament's primary role and supremacy. These judgments ensure that while the executive has this emergency power, it cannot be used to subvert the normal democratic process.
This power really illustrates that constant tension, doesn't it, between the need for quick executive action in crises and the fundamental need for democratic oversight.
It perfectly encapsulates it. Article 123 is a critical tool for the executive in genuine emergencies, yet it's meticulously checked by Parliament's review window, by disapproval resolutions, and ultimately by the judiciary's power to review the satisfaction and prevent abuse like repromulgation. It's a prime example of the dynamic checks and balances in India's constitutional framework.
Okay, so beyond lawmaking and these emergency powers, Parliament also wields incredibly strict control over the nation's finances, and it meticulously manages its own internal workings. Let's dive into that aspect of its power now.
Parliament's financial control and internal affairs.
Absolutely. The bedrock of parliamentary financial control lies in Articles 112 through 114. These outline the entire process for the annual financial statement, which everyone across India knows as the union budget.
Right, the budget. Article 112 basically mandates it, doesn't it? It's the starting gun for the financial year.
Correct. Article 112 is the core mandate. It says the president must, for every financial year, April 1st to March 31st, cause to be laid before both houses of Parliament a statement of the government's estimated receipts and expenditures. The annual financial statement.
And there's a key distinction within that statement, right? Between different types of expenditure.
Yes, a very important distinction. Between expenditure charged on the Consolidated Fund of India and other expenditure proposed from the Consolidated Fund.
Charged expenditure. That sounds like it's non-negotiable, almost pre-approved. What does that cover?
It covers critical, constitutionally mandated payments, things considered essential to the functioning and independence of the state. Think of the president's salary and allowances, salaries and pensions of Supreme Court judges, debt charges of the government, salaries of Parliament's presiding officers.
So things vital for the state machinery.
Exactly. And these sums are not subject to a vote in Parliament.
Not voted on at all. Why?
The constitutional design is to ensure the independence and continuity of these essential services and constitutional offices. It shields them from annual political bargaining or potential interference. You wouldn't want Parliament debating whether to pay the judges' salaries each year based on political whims.
Makes sense. And the other expenditure.
That forms the vast majority of government spending, everything else proposed from the consolidated fund. And that is subject to parliamentary vote. This whole Article 112 is the foundation for parliamentary control over public finances, ensuring transparency and scrutiny.
So Article 113 then details how Parliament actually handles these estimates, how it votes or doesn't vote.
Precisely. Article 113 provides the procedural blueprint. Charged expenditure, while it can't be voted upon, can be discussed in either house, so there's still oversight and scrutiny.
They can talk about it, just not block it?
Right. Votable expenditures, however, are presented exclusively to the Lok Sabha.
Only Lok Sabha again.
Yes, in the form of demands for grants.
Demands for grants. And the Lok Sabha has the final say on those. This sounds like the real power of the purse.
It absolutely is. The Lok Sabha has the power to assent to these demands, refuse assent entirely, or, and this is a key tool, assent to a demand subject to a reduction, often through what are called cut motions.
Cut motions, like proposing to spend less on something.
Exactly. It's a direct and powerful tool for the directly elected House to control government spending, ensuring public money is dispersed according to the will of the people's representatives. It's also important that no demand for a grant can even be made without the president's recommendation.
So the government proposes, but Lok Sabha disposes, essentially.
That's a good way to put it. It balances executive initiative with stringent legislative approval, primarily by the Lok Sabha.
Okay, that makes sense. Keeping the executive accountable. And then Article 114 seems to wrap up this whole budget cycle with something called appropriation bills, legalizing the spending.
Yes, Article 114 is the ultimate step. It's what actually makes the spending legal. After the Lok Sabha has voted on the demands for grants, an appropriation bill is introduced.
What does this bill do?
It authorizes the appropriation, meaning the withdrawal of monies from the Consolidated Fund of India, to meet both the grants already voted by the Lok Sabha and also the expenditure charged on the Consolidated Fund.
So it bundles everything together for final legal authorization?
Correct. And this article contains a fundamental rule, a bedrock principle of public finance. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article.
So without this specific Appropriation Act, the government literally cannot spend any money, even if the budget was approved in principle.
Exactly. It's a huge, fundamental check on executive power. The tap doesn't open until this specific law is passed.
Are there any restrictions on amending these appropriation bills themselves? Can Parliament try to change spending plans at this very last stage?
Generally, no. To ensure the efficiency and integrity of the budgetary process, no amendment can be proposed to an appropriation bill that would vary the amount or alter the destination of a grant already voted on, or vary the amount of charged expenditure. The presiding officer's decision on whether an amendment is permissible here is final.
So it locks in the decisions made during the demands for grants stage.
Precisely. It completes the budgetary cycle, makes government expenditure legally permissible and accountable, and ensures funds are used exactly for the purposes approved by Parliament.
It seems like a very rigid, tightly controlled system. But what happens if, things change? If the government suddenly needs more money mid-year for something unexpected, or if they seriously underestimated costs?
Well, the Constitution anticipates that too. That's where Articles 115 and 116 come in. They allow for a crucial flexibility.
How so?
Article 115 provides mechanisms for the government to seek additional funds beyond the initial annual budget. It ensures public services can continue even if original estimates fall short or new needs arise.
What are these mechanisms called?
There are three main types. Supplementary grants, used when the amount sanctioned for an existing service in the main budget proves insufficient.
Okay, topping up an existing fund.
Additional grants,
Yeah.
for expenditure on a completely new service, something not even thought of in the original budget. Think of a major natural disaster response or launching a brand new government initiative mid-year.
Right, something unforeseen.
And excess grants. These are usually post facto, after the year ends. They regularize money spent on a service in excess of the amount granted for that year, typically after audit reports reveal the overspending.
So even if they overspend, they still need Parliament's approval after the fact.
Yes. The key is that the same stringent procedures of Articles 112, 113, and 114 Presentation, discussion, voting in Lok Sabha, Appropriation Bill apply to all these additional grants too. Parliamentary scrutiny and authorization remain paramount.
Okay, so even with extra needs, Parliament stays in control. Now, what about Article 116? It mentions votes on account and votes of credit. Those sound like real emergency or maybe transitional measures.
They are exactly that.
Yeah.
Article 116 allows for grants in special circumstances that kind of override the standard lengthy budgetary process, but still emphasize parliamentary control even in urgent situations.
Let's take the vote on account. What's that?
A vote on account is a really crucial practical mechanism. It allows the Lok Sabha to make an advance grant for just a part of the financial year, typically for 2 months or so, while the full budget process is still pending completion.
Why would they need that?
It's especially vital during election years, or when there's a transition between governments. It ensures essential government functioning continues, salaries get paid, ongoing schemes are funded while a new government settles in, or the full budget debate concludes. It keeps the lights on.
This sounds very sensible. A pragmatic solution for transitions. Now, what's a vote of credit? That sounds more dramatic.
It is. A vote of credit is a rare and extraordinary power. It allows Parliament to grant funds for an unexpected demand of significant magnitude or where the details are indefinite. Think of wartime expenditure, or maybe a massive, sudden economic crisis response.
So it's like a blank check for a major emergency.
Essentially, yes, given by Parliament for truly unforeseen and critical needs where the exact breakdown isn't possible beforehand. Article 116 also mentions exceptional grants for special purposes outside the normal financial year services.
So why do all these special grant provisions exist?
They ensure essential government functioning can continue even when the full budget isn't passed on day one, or allow the government to respond rapidly to truly critical, unforeseen needs. But importantly, they all still require parliamentary approval for expenditure, maintaining that fundamental principle.
Okay, so we've thoroughly covered how laws are made and how the national finances are meticulously controlled by Parliament. Now, let's go sort of behind the scenes and look at Parliament's internal affairs. How does Parliament actually manage its own house, its day-to-day operations, its rule, its conduct?
Right, that's covered by Articles 118 to 122. These deal with the procedure generally in Parliament, basically, its internal rulebook. Article 118 is foundational here.
What does 118 say?
It establishes that each House of Parliament, the Lok Sabha and the Rajya Sabha, has the autonomy to make its own rules for regulating its procedure and the conduct of its business, all subject to the Constitution, of course.
So Lok Sabha and Rajya Sabha can set their own internal rules, almost like their own mini constitutions for how they run debates, committees, member conduct.
Exactly. This ensures internal self-governance and allows for the efficient functioning of the legislative bodies, tailored to their specific needs and traditions. They know best how to manage their own affairs.
What about joint sittings? Who makes the rules then?
For joint sittings, which we discussed earlier for breaking deadlocks, the president makes the rules, but in consultation with the chairman of the Rajya Sabha and the speaker of the Lok Sabha. And remember, the speaker of the Lok Sabha presides.
Okay. Now, what about financial business specifically? Does Article 119 give it special treatment, maybe overriding the general rules?
It does. Article 119 provides a special power precisely for that. To ensure the timely completion of crucial financial business, like passing the budget, Parliament can enact a specific law-regulating procedure just for financial matters.
And that specific law would take precedence.
Yes. Such a law will prevail over the general rules of procedure made by the individual houses under Article 118.
Why is that needed?
It's a pragmatic recognition that financial stability is paramount. It justifies having a mechanism to prevent procedural delays from holding up the nation's budget, which could have really severe national consequences. Time is of the essence with the budget.
Makes sense. And language in Parliament. India is incredibly diverse linguistically. That must be a fascinating challenge for internal rules.
Absolutely. Article 120 directly addresses this. It states that business in Parliament is transacted in Hindi or English.
Hindi or English? But what about members who aren't fluent in either?
Crucially, Article 120 includes a provision for inclusivity. The presiding officers, the chairman, or the speaker can permit any member who cannot adequately express themselves in Hindi or English to address the House in their mother tongue.
That's vital for participation, surely?
It ensures broad participation from all corners of the country. And while the original constitutional intent was perhaps to phase out English after 15 years, Parliament passed the Official Languages Act in 1963, ensuring its continued use alongside Hindi, reflecting the linguistic realities.
Okay, so we've got Rules for debate, finance, language. Now, what about restrictions on what can even be debated? I'm thinking specifically about the conduct of judges. Is that off limits?
It largely is. Article 121 provides a vital constitutional shield for judicial independence. It states there can be no discussion in Parliament regarding the conduct of any Supreme Court or High Court judge in the discharge of their duties.
No discussion at all. That's a strong protection.
It is. The sole exception is during a formal motion for presenting an address to the president for the removal of the judge, the impeachment process itself.
Only during impeachment proceedings.
Correct. Otherwise, their conduct in office is off limits for parliamentary debate. This ensures judges are protected from political criticism and pressure, allowing them to perform their duties without fear or favor. It's essential for an impartial judiciary and the separation of powers.
That's a very clear line protecting the judiciary. But then Article 122 seems to offer protection in the other direction, stopping courts from looking into Parliament's proceedings. Is that an absolute immunity? Can Parliament do whatever it wants internally?
This is where the checks and balances become incredibly dynamic and, frankly, quite fascinating. Article 122 states that the validity of any proceedings in Parliament cannot be called into question in court on the ground of any alleged irregularity of procedure.
So procedural mistakes are off limits for courts.
Yes, generally. It also grants immunity to parliamentary officers or members who are regulating procedure or maintaining order. They're immune from court jurisdiction for exercising those powers. However,
There's always a however with constitutional law, it seems.
there often is. This immunity is not absolute. The Supreme Court has clarified this, particularly in landmark cases like Raja Rampal v. Honorable Speaker Lok Sabha, the famous Cash for Query case in 2007.
What did the court say then?
The court clarified that while procedural irregularities are immune, courts can inquire if there is a substantive illegality or unconstitutionality or a clear lack of jurisdiction in Parliament's actions.
So if Parliament breaks its own rules, courts stay out. But if Parliament breaks the Constitution itself or acts totally outside its powers, then the courts can step in.
Exactly. Parliament's internal affairs are generally out of bounds for the judiciary based on procedure, but not if they violate the fundamental principles of the Constitution itself. Parliament still has to operate within the constitutional framework.
It's a fascinating tightrope walk, isn't it? Balancing parliamentary autonomy with the judicial oversight.
Precisely. Article 122 strikes a delicate but crucial balance. It protects Parliament's internal functioning, but ensures the judiciary remains the ultimate guardian and interpreter of the Constitution. It's a testament to the intricate system of checks and balances, ensuring no branch, even in its own domain, operates entirely beyond constitutional limits.
So we've navigated the intricate legislative framework, seen how laws are made, finance is controlled, internal rules operate. Now, let's turn our attention to the very top of the judicial pyramid, India's Supreme Court, the ultimate guardian of this whole complex constitutional setup.
The apex of justice in the Supreme Court.
Yes, Articles 124 to 127 are the bedrock for the Supreme Court. Article 124, in particular, lays the foundational groundwork. It defines the court's composition, the stringent qualifications needed to become a judge, and the meticulously designed process for their removal, all fundamentally aimed at ensuring judicial independence.
Okay, let's start with composition. How is the Supreme Court structured? How many judges? And who qualifies?
The Supreme Court consists of a Chief Justice of India, the CJI, and a number of other judges. The Constitution initially set this number at not more than 7, plus the CJI.
Only 8 judges initially. Wow.
Yes, but Parliament has the power to increase this number by law, and it has done so multiple times, mainly to cope with the ever-increasing caseload. As of a 2019 amendment, the sanctioned strength is the CJI plus 33 other judges, so 34 in total.
And qualifications.
Yeah.
What does it take to get onto the highest court?
To be a Supreme Court judge, a person must first be a citizen of India, and then they must meet one of 3 criteria. Either 1, have been a high court judge for at least 5 years consecutively,
Okay, judicial experience.
or 2, have been a high court advocate, a lawyer practicing in a high court for at least 10 years,
Legal practice experience.
or 3, be a distinguished jurist in the opinion of the president.
A distinguished jurist. That sounds broader. Has that category ever been used?
Interestingly, no. That third category has never actually been invoked for an appointment to the Supreme Court. It highlights a strong preference, in practice, for those with established judicial or senior advocate backgrounds.
Okay. And once appointed, what's their tenure like? How secure is their position? You mentioned removal is tough.
Very secure. Judges hold office until they reach the age of 65. This ensures a long and stable tenure, allowing for deep institutional knowledge and experience. And yes, removal is incredibly difficult. They can only be removed through that exceptionally rigorous impeachment process we touched on earlier.
Remind me how that works again.
It's outlined in Article 1, 2 PR 4, and 5. It requires an order from the president, but only after an address by both houses of parliament. And each house must support that address by a special majority, that's a majority of the total membership, and a majority of at least 2/3 of the members present and voting.
That sounds almost impossible to achieve politically.
It's designed to be incredibly difficult, precisely to protect judges from political pressure or removal for unpopular decisions. The grounds are also very specific: proved misbehavior or incapacity. Furthermore, there's a post-retirement restriction.
What's that?
A Supreme Court judge, once retired, is prohibited from pleading or acting in any court or before any authority within India. This aims to maintain the dignity and independence of the office, preventing any perception that a judge might rule a certain way to secure future employment or favor.
That sounds like a really robust system on paper, designed for independence. But the actual process of appointing these judges,
Yeah.
that's been one of those contentious and dynamically evolving areas, hasn't it? This is where the executive and judiciary have really clashed.
Oh, absolutely. What's truly fascinating here is how the interpretation of just a few words in Article 124.2 has completely transformed the system.
Which words are those?
Article 124.2 says judges are appointed by the president after consultation with such of the judges of the Supreme Court and of the high courts as the president may deem necessary. The entire battle has hinged on the meaning of consultation.
Consultation. Seems simple enough, but clearly wasn't.
Far from it. It's undergone a dramatic, almost revolutionary evolution through judicial interpretation. This is where we witness a genuine constitutional battle for who ultimately controls judicial appointments.
Okay, let's trace this evolution. It sounds like it completely flipped the power dynamic.
It started with the first judge's case, S.P. Gupta v. Union of India, back in 1981. The Supreme Court initially interpreted consultation to mean simply an exchange of views.
So the president, acting on government advice, had to ask the judges, but didn't have to agree with them.
Exactly. It effectively gave the executive primacy in judicial appointments. The government had the dominant say. This was the era of executive primacy.
Okay, so the government basically had the final word back then. But that didn't last long, did it? There was a massive shift.
No, it didn't last. A profound and, frankly, radical shift occurred with the second judge's case, Supreme Court Advocates on Record Association VUOI in 1993. A larger 9-judge bench overruled the S.P. Gupta decision.
Overruled it completely. What did they say consultation meant then?
They declared that consultation in this context must be understood as concurrence.
Concurrence, meaning agreement.
Yes, making the judiciary's recommendation effectively binding on the president. This landmark judgment formally devised what we now know as the collegium system.
The collegium system. Explain that.
Under this system, the Chief Justice of India, in consultation with the 2 senior-most Supreme Court judges at that time, would make the recommendations for appointments. This was a direct, forceful assertion of judicial primacy. The power shifted dramatically from the executive to the judiciary itself.
So from executive primacy to judicial primacy, that's a huge swing based on interpreting one word. And was the collegium refined further?
Yes. The third judge's case in 1998, which was an advisory opinion sought by the president, further refined the collegium. It clarified that the CJI must consult a larger body, the 4 senior-most Supreme Court judges, not just 2 for recommendations to the Supreme Court.
So the group got bigger.
Right. This firmly cemented judicial primacy, establishing this unique system where the judiciary largely controls its own appointments and succession. Judges appointing judges, essentially.
But then Parliament tried to push back against this judge-made system, didn't they?
Yeah.
Trying to reclaim some executive or external say. This brings us to the NJC attempt in 2014.
That's right. The National Judicial Appointments Commission, or NJJC Parliament, through the 99th Constitutional Amendment and the NJJC Act, attempted to replace the collegium entirely.
What was the NJJC supposed to look like? Who was on it?
It was designed as a 6-member body. It included the Chief Justice of India, the next 2 senior-most Supreme Court judges, the Union Law Minister.
Ah, the executive is back in the room.
Yes. And crucially, two eminent persons to be nominated by a committee consisting of the Prime Minister, the CJI, and the leader of the opposition.
Eminent persons. So non-judges, non-politicians, potentially.
Potentially. It was a legislative attempt to introduce more executive and external participation, partly to address criticisms about the collegium being too opaque, too insular, lacking democratic accountability.
And how did the Supreme Court respond to this direct legislative challenge to its collegium system?
Predictably, perhaps, the Supreme Court pushed back hard. In another landmark verdict, the fourth judge's case in 2015, a 4.1 majority struck down both the 99th Amendment and the NJREC Act.
Struck down a constitutional amendment. On what grounds?
On the grounds that judicial primacy in appointments is an essential feature of the independence of the judiciary, which itself forms part of the Constitution's basic structure.
The basic structure doctrine, again, that powerful judicial tool.
Exactly. The court held that certain fundamental principles of the Constitution cannot be amended, even by Parliament with the required majorities, because they form the core identity of the Constitution. And they saw judicial independence in appointments as one such feature.
And the NJGC threatened that independence, in the court's view.
Yes. The majority felt that the inclusion of the law minister and the potential veto power that the two eminent persons might have if they acted together, compromised judicial primacy and the fundamental principle of separation of powers.
So the judiciary effectively vetoed Parliament's attempt to change the appointment system, preserving its own collegium. What does this whole saga ultimately mean?
It's a remarkable story. It exemplifies the Indian judiciary's powerful, some would say assertive efforts to reinterpret the constitutional text to secure and protect its own institutional independence. It's led to this unique system, unlike almost anywhere else, where an unelected body, the judiciary itself, effectively appoints its own peers and successors.
But wasn't there a dissenting judge in that NJGC case? Didn't they raise concerns?
Yes, Justice Schellingswart wrote a strong dissent. While in the minority, he raised very valid criticisms about the collegium's lack of transparency, its opaqueness, and its lack of democratic accountability. His dissent highlights the deep philosophical tension that absolutely continues to this day, the tension between wanting an independent judiciary free from political interference and wanting accountability and transparency in how powerful judges are chosen. It's a debate that's far from over.
Fascinating. So judges are appointed with this hard-won independence. What about their financial security? That seems like another absolutely critical piece of the independence puzzle. Can the government put financial pressure on them?
The Constitution takes great care to prevent that. Article 125 is specifically designed to secure the financial independence of Supreme Court judges, recognizing it as fundamental to their ability to dispense justice without fear or favor.
How does it do that? Who sets their salaries?
Their salaries, privileges, allowances, and rights regarding leave and pension are determined by Parliament through law. So Parliament sets the framework.
But wait, if Parliament sets the salaries, couldn't they just reduce them if they don't like a judge's rulings? That seems like a loophole.
But here's the crucial safeguard. The proviso to Article 125(2) explicitly states that neither the privileges nor the allowances of a judge, nor his rights in respect of leave of absence or pension, shall be varied to his disadvantage after his appointment.
Cannot be varied to their disadvantage. That's the key phrase.
That is the absolute key. It's a robust constitutional shield. Once a judge is appointed, their financial terms cannot be worsened. This prevents the government from punishing a judge financially for unpopular decisions or trying to exert pressure that way.
Any other financial protections?
Yes, another important one we touched on earlier. Their salaries and allowances are charged on the Consolidated Fund of India, as per Article 112. Remember what that means.
They're not subject to an annual vote in Parliament.
Exactly. They are paid automatically as a matter of constitutional duty, not political discretion each year. This further insulates them from political pressures related to the budget cycle.
That's a truly robust set of financial safeguards. It seems designed to ensure that highly qualified people are attracted to the bench and, once there, can function impartially without worrying about financial repercussions.
That's precisely the goal. Financial security is seen as indispensable for judicial independence.
Okay, so beyond permanent appointments and their security, how does the Supreme Court manage temporary needs or staffing challenges? Say, if the Chief Justice is briefly unavailable, or if there's just a sudden vacancy or an overwhelming caseload.
The Constitution provides for that too, through Articles 126 and 127. These provide mechanisms for temporary judicial appointments to ensure seamless continuity and functional capacity.
Let's take Article 126 first. Appointment of an acting Chief Justice. That sounds pretty straightforward.
It is, largely. Article 126 is mainly an administrative provision. When the office of the Chief Justice of India is vacant, or if the CJI is temporarily unable to perform their duties due to abscess or illness or something else, the president appoints one of the other Supreme Court judges to perform those duties for the interim period.
So purely for administrative continuity at the very top.
Exactly. Ensures the court's leadership is always active.
Now, Article 127 deals with ad hoc judges. That sounds different. What was the original idea behind appointing ad hoc judges?
Originally, Article 127 was intended for a very specific situation. If there was a lack of a quorum of judges available to hold or continue a particular session of the court, you need a certain number of judges to hear cases.
So if too many were sick or recused, maybe.
Something like that. In such a case, the Chief Justice of India, with the President's prior consent and after consulting the Chief Justice of the relevant High Court, could request a qualified High Court judge to sit temporarily as an ad hoc judge in the Supreme Court, just to make up the numbers for that session.
Okay, seems sensible for ensuring court business isn't disrupted. But you said originally has its application changed. This sounds like another area of dynamic interpretation.
It absolutely has. This is where a seemingly dormant provision has seen a remarkable reinterpretation and revival in recent years.
How so? What's happening?
The big shift came with the Lok Prahari v. Union of India case in 2021. The Supreme Court, explicitly recognizing an unprecedented situation of massive case backlogs, a huge problem, particularly in the high courts, but also affecting the Supreme Court, dramatically reinterpreted and activated this Article 127.
Activated it to deal with backlogs, not just lack of quorum.
Exactly. The court issued guidelines for appointing retired high court judges who are qualified as ad hoc judges, not just for specific sessions, but more systematically to help tackle the crisis of pending cases.
Wow. So a provision designed for temporary quorum issues is now being used as a tool for systemic problem solving to improve judicial efficiency and clear the docket.
Precisely. It marked a significant shift in purpose, from merely addressing a temporary lack of judges for a hearing to using ad hoc appointments as a strategic tool to reduce the staggering number of pending cases that clog the justice system.
That's a really proactive step by the judiciary to address a major systemic issue. But does this reliance on ad hoc appointments pose any potential downsides, any unintended consequences?
That's the critical question, isn't it? While it's a proactive and arguably necessary step to address the immediate crisis of arrears, this reliance on ad hoc appointments does present potential challenges.
Like what?
Well, one concern is that it could inadvertently create an incentive, or at least reduce the pressure on the executive, to delay filling permanent vacancies in the high courts and Supreme Court. If you can plug gaps with temporary judges, does it lessen the urgency to make permanent appointments?
Ah, so it could potentially mask the deeper problem of understaffing.
It could, potentially. It might perpetuate the very issue it aims to solve by making the chronic understaffing seem less critical. It adds another fascinating layer to that ongoing executive-judiciary dynamic. A judicial solution to a systemic problem might have unintended administrative and political consequences, constantly testing the system's resilience and highlighting the need for holistic reforms, not just temporary fixes.
That's a truly insightful point. Even well-intentioned solutions can introduce new complexities. It really highlights the dynamic, living, and constantly adapting nature of constitutional governance in India. Outro. Okay, let's try and unpack this incredible journey we've taken today. It's been quite a ride through India's constitutional machinery.
It really has a lot to cover.
We've navigated through the intricate legislative process, right? From ordinary bills negotiating the two houses, the whole prorogation versus dissolution dance.
To the specialized, very Lok Sabha-dominant paths of money bills and the hybrid nature of financial bills, each with its own unique set of rules designed ultimately for accountability and efficiency.
Then we explored the president's critical role. Not just stamping assent on laws, but also wielding that powerful emergency legislative power through ordinances.
A power that's very carefully checked, though. Checked by Parliament's timeframe and disapproval power, and, significantly, by the judiciary's ability to review the satisfaction and prevent abuse like endless repromulgation.
Absolutely. And then we dive deep into the heart of India's judicial system. We look at the Supreme Court's foundations, that incredibly contentious evolution of judicial appointments through the collegium system.
Their whole battle over consultation versus concurrence.
Right. And the robust safeguards, both procedural and financial, designed to protect judicial independence, positioning the court as the ultimate guardian of the Constitution.
So, what really stands out to you here, thinking back over all this?
For me, it's that constant dynamic interplay. The checks and balances aren't just theoretical. You see them actively working, sometimes creating friction, sometimes collaboration. There's this continuous interpretation and reinterpretation.
I agree. India's constitutional architecture isn't some static blueprint gathering dust on a shelf. It's a living document. It's constantly adapting, responding to the needs of a vibrant, incredibly complex, and evolving democracy.
Yeah, the intense debates we see, the landmark judgments that shift understanding, even these dormant provisions like Article 127 suddenly being brought back to life to tackle new problems. It all speaks to the resilience, but also the fluidity of its governance.
It's truly a marvel of institutional design and adaptation, isn't it? These articles aren't just about who holds power, they're fundamentally about how power is exercised, how it's limited, and how it's held accountable in a democratic republic.
It's a testament to the foresight of the framers, definitely, but also to the continuous, sometimes messy evolution through political practice and judicial review. It keeps the system responsive, hopefully, yet robust.
And if we connect this to the bigger picture, right? These foundational articles, so meticulously designed for checks and balances, they also create this incredibly complex web of interdependencies. It's a system that's constantly testing its own resilience, which leads to a final thought, maybe. What do you think is the greatest challenge facing constitutional governance when powers are balanced so intricately?
That's a big question. Is it the potential for gridlock, where checks become blockades?
Or is it the constant temptation for one branch to try and overreach into another's domain?
Or maybe just the sheer difficulty of interpreting centuries-old principles in a rapidly changing modern world?
It's probably a mix of all three, isn't it? It's a question that keeps the system vibrant and forces it to be responsive, but also ensures it's continuously in flux, always seeking that elusive, perfect balance.
That is a powerful thought to leave with our listeners. The journey through India's constitutional architecture truly reveals a system in constant motion, always striving. Thank you for joining us on this deep dive.
Thank you.
We hope you found some profound aha moments in there.
Yeah.
Until next time, keep digging deeper.